You might have heard of the first and second rounds that happened in 2009, the first and second oil rounds of petroleum licensing. 14 companies were pre-approved to take part in the oil licensing. The first bid round was in June of '09, I believe, and the only successful company who took advantage of that first bid round was the consortium between British Petroleum and Chinese National Petroleum Company for the Rumaila field, which is one of the many supergiant fields that are in Iraq in the Basra Governorate. It's a very productive field. It's the closest field to the offloading port at Qasr, and it also is a field that BP has been involved in for 30 years, I think. They have a long-term knowledge of the engineering and of the understanding of that field, and therefore they would not pass up an opportunity to do it. There were some problems in this licensing round. The Iraqi government hired a very well-known and a very well-established oil consulting company from the U.S., and they developed a contract called the TSC, the Technical Services Contract, that ensured and did its best to ensure that the majority of profits, as many profits as they could, stayed in Iraq. And that's logical to me. It's the Iraqi people's resource, and they should have as much right of return in those funds as possible. But it really amounted a lot of consternation within the IOCs, the international oil companies, especially super majors, that were used to going into different countries around the world and having their say or their way with contracts that they had developed. But if you have a chance, in the Middle Eastern Policy article, we cross-referenced what the amount of remuneration fees, the amount of barrel target that each field is allowed or is targeted to produce. And it's a very aggressive and almost untenable goal given out by these fields. And that's why only one consortium took advantage of this. Just as a side note, there were 21 successful consortiums in the first and second bid round out of 2009. 17 involved Chinese partners. So out of the vast majority of the vast majority, 80% or so of all the consortiums there involve the 4 state-owned Chinese national oil companies. So, just food for thought. The second and third fields to go out of that first round were not awarded on the television, the nationally televised rounds. They were out-of-round negotiations between the different companies and the Ministry of Oil, and terms were slightly negotiated along the way. The first round has a very problematic aspect to it that a lot of the oil corporations that we speak to were turned away with, and that is it has something called the FOD. It's a hybrid nonprofit built between the International Oil Company and the state party. So you have to be in business with the state party, in this instance the South Oil Company, and you will share resources, and the state oil party will second employees to the International Oil Company. So they're in kind of a power-sharing agreement with the state-run companies, again, to keep as many revenues as possible back within Iraq. The second round was much easier because they dropped that requirement. They dropped the FOD requirement out of the negotiation. They probably learned from the first round. They moved on and they created a separate contract called a DPSC, a service contract as well. And they had a much more successful second round licensing than the first round. There's now a third round scheduled in Iraq. It's only for natural gas and doesn't involve any petroleum resources. So as you can see, if there's one theme to the petroleum trend, it's that the Iraqi government is open for business. I think the last estimates were over 100,000 foreign employees are scheduled to enter Basra Governorate in 2010, 2011. And it's not just the IOCs that we're talking about here. It's the service contract providers. There's one step down. It's then all the smaller companies that service them. So it's a massive amount of undertaking to develop these fields that have really they've been developed, but they haven't been developed well. And the technology that's there sitting on these fields is circa 1967. And so I think the Chinese engineers do have a challenge ahead of them for the work that they'll do, because to develop these fields up to the point where you can meet that level is an incredible endeavor, and it won't happen in the next year or two. It might happen in 3 to 5 years. So that's definitely trend one. The problems that we saw in the first and second oil rounds, as I said, the FOD structure was problematic. A lot of the fields that were awarded out of this first and second round, there was no research into who lived on these fields. So the field might be there, and they might know where the petroleum is in that field, but there's no idea of who owns that land. And the Iraqi land registry is not computerized, so to actually determine who owns this land and if it's possible to drill on this land involves essentially a land research company, a title research company, to investigate these issues. As I said, the secondment issues. So you have SOC and NOC Iraqis working with the international oil companies as their employees or as their seconded employees, and how that's going to work out between these two companies is always going to be a difficulty. Are they going to treat them as employees, or are they going to treat them as secondees? Hasn't been resolved. As I said, the remuneration fees are very high as compared to other developing areas of the world, compared to Angola, Indonesia, and other areas that these super majors are involved in. A lot more of those profits are going to stay in Iraq than go to the IOC. And then I think it's the big elephant in the room are the legal ambiguities that surround these contracts. There's a law in Iraq. It's called Law 97 of 1967, which requires that all foreign contracts with non-Iraqi companies have to be ratified by Parliament to be legal. So all of these awards that I just described, all of these contracts that I just described, under a theory, under I think a conservative legal reading of this law, are illegal under Iraqi law and possibly unenforceable. The Iraqi government disagrees, and they've published a series of articles and opinions stating the opposite. But at most, if you take their view and take the preceding view, it's unsettled issue. Whether these are going to be an enforceable contract. And if you're going to invest $1 billion, if you're going to invest massive amounts of money, and the entire thing could be illegal or unenforceable in the first place, the whole underpinning could be either nationalized, taken away from you, or just simply illegal in the first place. So that's one of the big problems that we're seeing here. This question was challenged in federal court. A parliamentarian who was not reelected or did not run in the March elections challenged it and said these contracts are illegal based upon this law. They shouldn't be here. They are entirely contrary to Iraqi jurisprudence. She initiated, her name was Shada Moussawi. She started this action in the federal court of Iraq, which is the proper court. It's currently pending, and I think next week or this week we are up for the next stage of the litigation. But in any case, it's common knowledge. This is not hidden. People discuss it, and there are contrary viewpoints. These type of laws aren't uncommon. I think Venezuela has one as well. So they're a product of, again, the 1960s, the socialist nationalist movement in the Middle East. But Parliament has essentially said, we think we're not going to pass the law. We're not going to ratify these contracts, and not one of these has been ratified.